Right. This is a jail appeal challenging the impugned judgment and order dated 15/12/2021 passed by the Special Court NDPS Champai in Criminal Trial 1691/2019, by which the appellant has been convicted under Section 21C of the NDPS Act and sentenced to undergo where the sentence? There's no sentence. And has been sentenced under Section 21C. Admit the appeal, call for the LCR. He lists the matter after 4 weeks. Mrs. Linda L. Fumble, BP, accepts notice on behalf of the state. This is the matter after 4 weeks.
See, sentence of orders on the page of okay, not to be ended. Sentence from the
What is this? A sentence of look, sentenced to undergo RI for 11 years with a fine of rupees 1 lakh in default, SI for 2 months. A registry to
or the district.
Okay, registry to appoint the MI secretary. Next.
Item 3.
This is a jail appeal filed against the judgment and order dated 5/7/2023 and sentence convicting the appellant under Section 376 bracket 2 bracket F IPC. The appellant has also been sentenced to undergo
Yes, next page. Second one.
to undergo
15 years. Second.
to undergo RI for 15 years with a fine of rupees 10,000, ID for 3 months. Same thing, huh? Same thing. Call for the LCR, okay? LCR in original
Item 4.
or LCR का original begin. Okay. Item 3. This is no. Where is item 3? It's item. Okay, this is a jail appeal challenging the judgment and order dated 25/8/2022 passed by the Fast Track Special Court POCSO Act IZOL in SC number 151 of 2015, by which Mrs. Vande Siami, learned counsel for
Government application.
the learned government advocate for the respondents.
1 to 5.
1 to 5
Yes, my lord.
is granted a further 3 weeks time to file affidavit in a position. Give a 4 weeks time, not 3 weeks. No point. Then who is for the private respondents?
It's the MPSC. Respondent number 6, MPSC.
Any private respondents? No.
No private respondents.
Okay. MPSC, who's appearing for MPSC?
Mr.
No.
J. Siran Sang had accepted notice earlier.
Okay. The MPSC should also file their affidavit within 4 weeks. List them out after 4 weeks.
Orders item 7.
Yes, Your Lordship, notice is complete.
On this respondent number 2. Okay.
Yes, my lord.
So paper book has to be made.
Yes, my lord.
Okay, right. Heard Ms. Vandesemi, additional PP, who has submitted the the form dated 30/01/2025, which shows that notice has been affected on the informant. Accordingly, notice is complete against all the respondents. As the LCR has arrived, registry to prepare the paper book. This is the matter after preparation of the paper book. Who do we appoint?
Legal aid counsel.
Who is the legal aid counsel?
Yeah, no. Okay. The district can appoint from the employment press. Legal aid counsel to employment list from the legal aid counsel.
Registry to appoint the amicus curiae for the case.
Oblige.
And legal aid counsel
And legal counsel, it's only
to represent respondent number 2. Oh, so they have not turned us.
No.
Okay, next day. Okay, amicus for the
Okay, Mr. Jonathan, you will be the amicus for this case. Okay, Mr. Jonathan L. Silo is appointed as the amicus curiae. If the respondent number 2 does not turn up on the next date, on the ground that he has not been able to engage a legal counsel, the appointment of a legal aid counsel may be considered on the next date.
Item 8.
So basically, we have
Water bottle.
See them, tell the follow.
The same, I just try and make.
Yeah,
it
yeah,
clear.
yeah.
Okay. See, we want to know whether you're going to say that he did not commit any crime against his wife, or he did commit some crime, but it does not come under 302, but it should be altered to 304. So is it that someone else must have committed the offense, or you're going to say that the husband did commit the offense, but it does not constitute an offense under 302? Which of those two submissions are you going to make?
I would like to submit in my humble opinion that the husband did commit the act.
He did do the act,
Yes,
but
but
it's not
not with
under
the intention
302.
to kill the wife.
So
How,
then
how
to
many
go
years
for-
experience do you have, madam?
8 years, my lord.
From now on, it should be 10 years minimum for the lawyers to take up these type of cases. You have to have some experience. You see, you have got to be very clear how you are going to approach a case. This is a murder case. We are 302. Now you have got to be very clear. Yeah, whether your case is going to be, yes, the appellant killed that person, or he did not kill that person. You have got to be very clear. If you take a decision that your stand is going to be that the appellant kills the victim, then again you have got to make another choice. Other choice is, was it an intentional killing or was it an unintentional killing? Because there are two different aspects. You see, intention and unintentional. Supposing a person shoots somebody A, but because he's such a bad, his aim is so bad, he kills B out there. So he killed B, but intention was not to kill B. So the punishments are different. There's 302, there's 304. In 304 also there's part 1, part 2. And then for a murder, a homicide, culpable homicide not amounting to murder, and there is homicide, there is murder. Then there is exceptions 1 to 4, 1 to 5, under 300. So you've got to be very clear in your concept of how you're going to argue a case. See, so that is why we want to know which bracket do you fit in. That's why we ask you, very beginning, what is your case going to be? Because if you are going to say there was no murder at all, he did not kill his wife, okay, then we'll just have to see whether
Someone else could have done that.
yes, that's all. Now, having an intention, not having an intention, two different lines again. So you've got to be very clear.
My lord.
I hope you are clear now what we want to know.
My lords, yes.
Yes. So what is your case going to be?
My case, as per the petition, appeal petition filed by the convict appellant, was that the action of his action was out of anger, and the consequence of her demise was an accidental cause of death.
So, he has admitted to the death,
Yes, my lord.
that he was the cause of the death of the deceased.
Yes, my lord.
So, but it was an accident.
Yes, my lord.
Correct.
My lord.
So, accident will come under what? Rash and negligent act? Can it come under rash and negligent act also? Let us see the appeal petition. Where is it? Let us see.
It is at page number 52, my lord.
It should. Yes. Give us IPC. IPC. Come to page 53.
My lord.
You please read from B.
B. On the day of the alleged incident, my wife was drunk and could not feed my baby, still suckling mother's milk. It was in the morning of dated 12/3/2021 that I woke up my wife to get up and feed my little baby her milk as the baby was crying for mother's milk. After getting up and letting her set up in a position to feed the baby on her lap, she suddenly collapsed to sleep again, keeping the baby crying. Having seen her unable to feed the baby in a drunken mood made me furious and highly angry as the baby could not stop crying. I could no longer control my anger and started to hold her hair and started to strike her against the bed and wall. She said she was sorry, but my anger grew more as she said sorry. I pulled her towards the bathroom, thinking that pouring water on her might help her awake. But pool of blood squeezed from her head and completely flooded the floor. After doing so, I left the house, telling her to feed the baby before I came back. During my absence, her sister and few other neighbors were there, and they scolded me why I beat my wife like that. They took her to Ebenezer, but to my dismay, she was declared brought dead. My action on my wife was out of anger, and the consequence of her demise was an accidental cause of death. Frankly, I did not intend to take her life. I just hit her head in a hope to punish her for being drunk. It was not intentional at all. It was a very unfortunate incident which I also never expected to happen.
Carry on.
Yes. See, the incident and consequence altogether had turned out in a much unexpected manner. I completely regret my action, and I did not blame anyone for the kind of sentencing I am given upon. But my plea for this appeal petition is that my kids are still very small and tender, and my parents are no more with us. My only brother and sister are not employed, and it's really difficult for them to shoulder the burden of my sinful deeds. My kids too are having hard time, not only to mention about what they will eat to survive, but who will take care of them when they are sick and in great difficulty. Therefore, you are requested to kindly show your mercy on my situation to the impugned judgment and order of the session court, and to set aside and quash the order in order to minimize the terms of my convictions at the lowest terms possible under your honorable court. I therefore would like to request you to kindly consider my humble appeal petition to set aside and quash of the said impugned judgment and order in session case number 45 of 2021, and sentence to undergo rigorous imprisonment for life, and sentences in criminal trial number 819 of 2021 under section 302 IPC, where I was convicted, and sentences to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000. In default of payment of fine, I shall have to undergo further simple imprisonment of 1 month, and I would also like to request your honor to kindly set aside and quash the said order and sentence, and set me free from the case, or sanction remission of my jail terms to the minimum year as per the law permits. For your kind act of your for which act of your kindness I remain thanking you in anticipation.
Okay, so you did not adduce any evidence, correct?
No, my lords.
Let us see your 313. Page
4.
Yes. Your evidence and your submissions. Come to the last answer, last
Yes.
question. Please read from the last question.
Do you have anything to say?
No, it is in evidence
Oh, it
at later at around 8 p.m.
It is in evidence that later around at 8 a.m. when you could not find the liquor you had hid and realized that your wife had consumed it, you were infuriated. At around 9 a.m. your daughter again started crying, and enraged you grabbed your wife by her clothing and dragged her down the floor from the bed, tearing off all her clothing, then smashed her head on the floor twice. Your eldest daughter, Lorenzuali, was also present at the time, begged you to stop assaulting your wife. After you assaulted you dragged her outside and into the bathroom. You poured water on her, trying to revive her. You then went to office between 12 noon to 1 p.m. and later to Rangva Mall to drink liquor again. What do you have to say? Accused: I did not hit my wife or assault her in any way. Our youngest child was sleeping and I tried to wake my wife up to look after the baby. Even when I left her in the bathroom, she was not fully awake, but she spoke and said she would look after the child.
What about the question and answer just before that?
Is it is it in evidence that
It is in evidence.
yes, it is in evidence that in the night of 11/3/2021 you were heavily intoxicated and you slept early. You were wakened up by the cries of your youngest daughter and you drank another 3 packs of liquor. After that, you watched TV in the sitting room with your wife. What do you have to say? This is true, by the accused.
Come to PW8, page 17. Please read from the beginning on essay.
On essay, accused Lerot Sanga is my biological father and the deceased Vanal Shwai is my biological mother. I have 2 other siblings and I am the eldest. I am studying in class 6 at Marymount School. I stay with my paternal aunt Helen Lal Chakimi, and after she leaves for work, I would go to my parents' residence. The incident took place during lockdown and we did not attend school. On the morning of 12/3/2021, my aunt Helen Lal Chakimi went out for work and I headed towards our house at Tuikwal South A. Just as I was about to reach, I met Pekka, who resided below my parents' house, and he said, "Hurry and save your mother." I was lost and did not understand the meaning of what he said. When I reached our home, my father was seated on the chair and he mentioned that he was going to put my mother on the main road. He beat her up with a belt and poured water on her ear. He hit her with a plastic bottle. When my father beats up my wife, he left her naked. My mother was lying on the ground while my father continued to abuse her. I shouted at my father to stop touching my mother. However, he did not obey me. I went out to call my auntie Mai for help, and my 2 younger siblings were at the house of my grandparents during this time. My mother and father were the only 2 people at home during this time. I brought Auntie Mai with me and we both entered the home. My mother was still lying motionless on the ground and Auntie Mai helped her on the bed and covered her bed with a cloth. Auntie Mai and I left and she took me to her home as my mother was in that condition and I stayed there for a while. Auntie Mai called and informed others and told them of my mother's condition. I did not see my mother thereafter, but I saw them take her to Ebenezer Hospital. I did not see her face, however. Cross-examination by the Learned Defense Counsel. I was just 8 years old when this happened. I did not live with my parents during the time. My father laid a hand on my mother. My father laid a hand on my mother. My parents both drink alcohol. In connection with paragraph 4 of my examination in chief, my father was not drunk during the incident. My paternal aunt is looking after me right now. Even if I were to choose the benefiting punishment to be given to my father, I have nothing to say. It is not a fact that I deposed falsely before the court today.
Next.
Page 19. Deposition of PW number 9, Zodin Puye. On essay, I know the accused Lerot Sanga. He is the husband of my friend deceased Vanal Shwaye. I know that the deceased Vanal Shwaye. She is my close friend. On 12/3/2021, around 11 a.m., Zwali, daughter of victim Vanal Shwaye, called me while I was in my shop, Kandor Kakan Innen Inzom, informing me that her father was assaulting her mother badly, Anu Ku Apanen Aninhawa Akabete Akaka Lautsukte, and asked me to come to their house. I went to their house and I saw that the victim was lying on the floor and her face was facing the floor in a naked position. Ravik in Swata Abokubzong in Alaoma. The accused Lerot Sanga was present at the time and was bothering about the victim. I shouted at him saying that how inhumane can he be assaulting the deceased Vanal Shwaye? The accused then answered me that the victim Vanal Shwaye had consumed the liquor which he had kept hidden and got blacked out. Satla. I called the victim and hearing me, she just uttered, And at that moment, the accused came and held the victim with her hair and pulled her inside the bathroom and he kicked her, pulled her hair and hit on the ground and poured water on her. I stopped him, saying that he should not treat his own wife in that manner, to which the accused says She deserves even worse than that. I was somehow afraid of the accused seeing his behavior towards the victim. I called his daughters Wali and her younger sister, who was nearly about 1 year old, whom I hold on my back, and went to our house. In the evening around 9 p.m., I took the two children of the victim, thinking that everything may be all right. The accused and his wife often used to have hot arguments on other days too. Therefore, I thought it will be the same. When I looked at the bathroom, I saw the victim still lying on the bathroom, her face towards the floor, and she was still in a naked situation. I asked the daughter of the victim, Zwari, to go and see her mother whether she was still breathing or not, but she said she could not understand anything, and therefore asked me to come inside the bathroom and to look at her. I was holding the baby in front, and therefore could not see and touch the victim. Therefore, I called the neighbors to come and see the victim. When we went to the house of the victim, the accused was not present in the house. The victim was just lying in the bathroom all alone and naked. When the neighbors came and hold the victim and shifted inside the when the neighbors came, they hold the victim and shifted inside the house and laid her on the ground. No one was sure whether the victim was still alive or not. She was shifted in a vehicle and later taken to Ebenezer Hospital. On March 31st, 2021, I was forwarded to ISO court by the police, and one lady magistrate recorded my statement in presence of some of her staff. Exhibit P4 is the judicial statement. Exhibit P4A is my signature. Cross-examination by the learned defense counsel. It is a fact that I was not present when the alleged incident was occurred. It is a fact that I do not know who hit first. It is also a fact that no materials were seized in connection with the present case. It is also a fact that both the accused and the alleged victim consumed liquor before the present incident was occurred. It is a fact that I was not present at the PO when the alleged victim was examined by the doctor. It is not a fact that I am deposing falsely.
Yes. What else? Now, so basically, why the deceased was still alive, if she could make a sound, he was still alive when PW9 went to the house,
Yes,
and the child saw the father beating up the mother.
yes, yes.
Now, your story that he got angry because he could not breastfeed the child.
Yes,
In the appeal petition, he said that
yes, my lord.
that he got angry because his wife fell asleep while breastfeeding the child. Now, that is nowhere seen anywhere. It's not in his 313. He has not stated that,
No, my lords.
but he has admitted that he was the one to do it. Now tell us, how are you going to project your case?
My lords, if I may have your attention at page number 82. This is the DNA examination report. Oh, firstly, I would like to have your attention at page 80 for wording note.
Page 80.
Yes, my lord.
Yes.
Several seized articles were sent to the FSL for examination, mostly for DNA profiling. However, it may be pertinent to mention that none of the alleged items used to beat up the wife, that is the Tupperware bottle, a plastic water bottle, and the belt, were never sent for any examination, which the PW8, the daughter, has said the convict appellant has used to beat up his wife. These are crucial materials which were never sent for any testing or any fingerprints examination.
So he did not hit her. Is what is the object of your submission?
The
What is the final
Yes, my
prayer
lord.
going to be, a final submission going to be.
Whether such
He did not hit her.
no, whether such materials is enough to cause the death of the victim, my lords. So even in the PME report,
Let's see the nature of injury.
even in the PME report, it was stated that there were external injuries, 9 external injuries and 3 internal injuries, but it was never compared the the materials, the alleged weapon used were never compared with the nature
There
of
was no weapon.
a weapon. I mean, like the materials used to hit the wife, my lords.
No, he banged her on the floor, bathroom floor, on the ground, pulled her hair and hit her on the ground and poured water on her head.
Yes.
So the cause of death.
But is it really enough to cause the death? How many times did they bang the head? Considering all
Well,
the...
she died anyway.
Yeah, she died anyway, yes. No questions. Was it enough to cause such death?
I don't know. You tell us.
That is what I am trying to say, my lord. So, given the circumstances of the case that the convict appellant has used the water bottle to beat up the wife, unless it's an axe or some heavy stuff,
And what did the appellant say in his appeal? He did not kill his wife.
no, he did not intend to kill his wife.
A different thing, madam.
Yes, my lord.
Now your submission is that he did not
He
kill his
killed
wife.
his wife, but oh my god.
But you said that the water bottle was not enough to kill his wife. So you have got to be very clear. Did he kill the wife with a water bottle or with something else?
Okay, it is an admitted fact that the convict appellant has said that he had killed his wife, but nothing on record has proven his intention, my lord. The intention to kill the wife was never proved. Only the assault was proved.
Why did he assault his wife? You don't go banging around your wife just for the fun of it.
No, because he was provocated, my lord.
How? Because
Because
he had his quota.
Because she was unable to feed the baby and the baby kept crying.
Who said that?
In his petition by the
In his
convict
appeal
appellant.
petition.
Yes, my lord.
But that is not what he said before the trial court.
No, my lord, he has denied everything.
That is why I say, when you take up cases like this, you have got to be very clear on how you're going to approach the issue. You cannot just say whatever you feel, You have got to be very sure whether you're going to go for altering the charge or not altering the charge. Anything else?
No, my lord.
Let us see the medical report. What does the medical report say? Whether water bottle was enough to kill the deceased or not. Page?
Page number 75.
75. Yes.
3I external injuries.
Yes.
Contusion of 4 by 2 centimeters present on the forehead, 1 centimeter above inner end of left eyebrow. 2. Contusion of 5 by 3 centimeters present on the left side of the forehead, above left upper eyelid. 3. An abrasion of 1 by 0.5 centimeter present on the left side of the forehead, 3 centimeters above the left eyebrow. 4. Laceration of 1 centimeter on the inner apex of lower lip. 5. Laceration of 2 by 0.5 centimeters present on the chin. 6. An abrasion of 1 by 0.5 centimeter present on the left side of back of the chest. 7. An abrasion of 1 by 0.5 centimeters present on left elbow. 8. An horizontally placed abrasion 8 by 0.5 centimeters present on the front of left side of the abdomen below the left hypochondrium. 9. Multiple abrasions present on the left knee. At page 78, internal appearances.
Yes.
Findings: A. Head, neck, and spinal column. A. Scalp. Contusion of inner layer of scalp present with diffused hematoma under the scalp. B. Skull. Fracture present on occipital bone.
So fracture present.
My lords. D. Brain. Diffuse subdural and subarachnoid hemorrhages present on both hemispheres of the brain.
So that cannot be done by a water bottle. Can it be done?
I would like to point out that the water bottle seized before the seizure witnesses was also empty.
Empty.
Yes, my lord.
Okay. So do you think that that empty water bottle was the cause of death?
No,
Okay, huh?
no, my
Let's go
lords.
to page 79. Let us see. What does it say?
Opinion of medical officer as to the cause of death. In my opinion, the cause of death is due to craniocerebral injuries, head injury. Time since death about 18 to 20 hours. Whether the injuries were antemortem or postmortem. Antemortem in nature. Age of injuries, time between inflictions of death, below 24 hours.
Anything else? So your basic case is that the water bottle was not sent to FSL. The empty water bottle and what
The belt
belt was not sent to the FSL.
and the place where the alleged where the smashing of the wife's head was occurred was never investigated.
Never investigated.
Was it the floor of the bathroom or was it the floor of the house? It was never established.
Okay. Anything else?
No, my lords.
Any citations in your favor?
I have only printed out one copy, my lords.
Okay, we share it. What to do? Maybe we'll cut it. We'll subtract it from your amicus curiae fees. Around 10 rupees it must cost for photocopy. Yes, give us. What is it? Yes, which para?
Para number 15.
15. You didn't give a list of books, or huh? You should have this habit of giving them, then they can get ready with the required books. Yes.
Para number 15. This court has time and again deliberated upon the crucial questions of distinction between section 299 and 300 of the code, that is culpable homicide and murder respectively. In Pulya Tadu versus State of Bihar, the court noticed that confusion is caused if courts losing sight of the true scope and meaning of the terms used by the legislatures in these sections allow themselves to be drawn into minute abstractions. The safest way of approach to the interpretation and application of these provisions seems to be to keep in focus the keywords used in the various clauses of these sections. Para 16, the court in Pulya Tadu provided the following comparative table to help in appreciating the points of discussions between these two offenses. Section 299, a person commits culpable homicide if the act is done by which the death is caused is done intention A, with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or C, with the knowledge that the act is likely to cause death. For section 300, subject to certain exceptions, culpable homicide is murder if the act by which the death is caused is done, intention 1, with the intention of causing death, or 2, with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or 3, with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or 4, with the knowledge that the act is so imminently dangerous that it must be in all probability cause death or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury as is mentioned above. Para 17. Section 300 of the code states what kind of acts, when done with the intention of causing death or bodily injury as the offender knows to be likely to cause death or causing bodily injury to any person, which is sufficient in the ordinary course of nature to cause death, or the person causing injury knows that it is so imminently dangerous that it must in all probability cause death, would amount to murder. It is also murder when such an act is committed without any excuse for incurring the risk or causing death or such bodily injury. The section also prescribes exceptions to culpable homicide amounting to murder. The exceptions spell out the elements to which need to be satisfied for application of such exceptions, like an act done in the heat of passion and without premeditation, where the offender, whilst being deprived of the power of self-control by grave and sudden provocation, causes the death of the person who has caused the provocation and causes the death of any other person by mistake or accident, provided such provocation was not at the behest of the offender himself. Culpable homicide would not amount to murder. This exception itself has 3 limitations. All these questions of facts that would have to be determined in the facts and circumstances of a given case. And at para number 25,
Yes.
as we have already discussed, classification of an offense into either part of Section 304 is primarily a matter of fact. This would have to be decided with reference to the nature of the offense, extent, intention of the offender, weapon used, and the place and nature of the injuries, existence of premeditated mind, the persons participating in the commission of the crime, and to some extent the motive of the commission of the crime.
So what are you trying to say, madam?
What I'm trying to say is that, my lord, for the convict appellant, though he has caused the death of his wife, the death of his wife was not intentional. So,
Not intentional.
not intentional. He only wanted to beat up his wife,
Beat up his
which
wife.
accidentally caused her death. Yes.
So to come to so now so which provision would be attracted?
provision, section 304, part 2, my lords.
Why? What does 304 part 2 say?
304, punishment for, section 304 IPC, punishment for culpable homicide not amounting to murder. Whoever commits culpable homicide not amounting to murder, no, part 2, or with imprisonment of either description.
No, no, madam. For 304 part 2
Okay.
to be applied,
Yes, whoever
you have
commits.
to first show that it is culpable homicide not amounting to murder.
Yes, my lord.
Now, for culpable homicide not amounting to murder, what are the conditions that are to be satisfied?
Culpable homicide not to be, homicide is not murder when the offender, while deprived of the power to self-control by grave and sudden provocation,
So
causes the death.
that comes under which section?
Section 300.
Now let us go to
Yes.
300.
Except
Firstly,
one.
yes, section 300 firstly. Please read.
Yes, section 300, murder, except in the cases hereinafter accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or secondly, if it is done with the intention of causing such bodily injury as the offender knows it likely to be cause the death of the person to whom the harm is caused, or thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or fourthly, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as it's likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Exception 1. When culpable homicide is not murder, culpable homicide is not murder if the offender was deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. The above exception is subject to the following provisos. First, that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. Secondly, that the provocation is not given by anything done in obedience to the law or by a public servant in the lawful exercise of the power of such public servant. Thirdly, that the provocation is not given by anything done in the lawful exercise of the right of private defense. Explanation: whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact.
How is it attracted?
Uh,
Let us read the first part.
yes, madam.
It says that culpable homicide is not murder if the offender, while deprived of the power of self-control by a grave and sudden provocation, causes the death. Correct?
Yes, madam.
Now, what does the proviso say? That the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm. That the provocation is not given so and so. Okay. Now, where is the provocation? From the part of the wife.
She was unable to feed the baby
Where have you said that?
in his appeal petition.
And appeal petition. But
Yes.
then you did not say that to the trial court.
No, my lords.
And how is so that is a provocation for you. Any other thing? That's all. So it could not feed. So that was
Because she
provocation
was in a
enough
drunken mood.
for killing the wife. Is the provocation proportionate to the crime committed?
In my humble opinion, no, my lords.
So can we say that the killing was justified or could come under this? It's like this: supposing a person comes at you with a small, say 1 foot stick to hit you, and you blast him with a tank. Is the provocation and the retaliation proportionate to each other?
No, my lords.
Supposing a 6-year-old boy scolds you or says something bad against you, 6-year-old, will it justify you hitting that boy with a hammer?
No, my lord.
So that is what I'm asking out here. Not feeding the baby, would it justify, would the provocation, with the retaliation be proportionate to the provocation?
No, my lord.
So can it come under section 300, the exceptions, exception 1, can it come under that? I'm asking questions. I'm not giving you answers. You have to, I want you to submit.
Uh, no, my lords, in my humble opinion.
Anything else?
No, that would be all, my lord.
Yes, Shannon.
Yes, Your Lordships. Based from the record and the evidence of the prosecution witnesses, my lord, the act of the accused cannot be placed under the sudden provocation, my lord. As per the rules, in order to plead against sudden provocation act, my lord, there are two ingredients which the appellant has to prove, and the provocation must be grave and sudden. And from the record, it can be seen that there is no grave provocation as well as no sudden provocation. It can be seen from the statement itself, from the accused statement itself, that the wife was sleeping at that time, and the appellant was the person who wake him. So there can be no provocation, my lord. And regarding the evidence of the two direct evidence, my lord, PW number 8 and 9, even though at the time of the death of the wife, even though they were not present, but they have witnessed the torture which the appellant had inflicted his wife by torturing her. And in this regard, my lord, the principle of last seen person, it can be applied, my lord. As per section 106 of the Evidence Act, the appellant has to prove himself how the death was caused, if he have the knowledge of the death. And the appellant witnesses, and he is the one who inflicted the injury, and there is no explanation regarding the death of his wife. And my lord, that part, it can be clearly seen from the evidence of Mr. Lalhundika, that is in page number 9 of the paper book, my lord. Page number 9.
Page number 9.
Yes, in the 8th line.
Yes.
Here he stated that the accused Lalwat Sanga, but the accused he called the accused when they found his wife. And he mentioned that the accused Lalwat Sanga, but the accused did not pay any heed to my information in respect of his wife Vanal Shwai. So, my lord, even though when they informed him that his wife was lying on the floor, unconscious, he didn't even pay attention. And from the act,
Maybe he thought she was sleeping.
no, my lord, he is the one who inflicted the injury. He himself
So
admitted
he
that
went out, he went off.
he went out, he left her. He left her to die in that bathroom, my lord. He admitted that he saw a pool of blood flowing out from his head, and still he left her.
Where did he admit?
In his appeal memo, my lord.
Appeal memo, can we now? You see, the judgment that is under consideration now has been passed on the basis of the evidence that was led in the trial court.
Yes, my
It
lord.
has not been passed on the basis of the appeal petition.
Yes, my lord.
Leave that aside. This is an afterthought.
During trial, my lord, he did not have any explanation regarding to the death of his wife. He admitted that he had inflicted the injury. He is the one who inflicted the injury. And there is no explanation that the cause of the death was done by other person also, my lord. He admitted that he is the one who had killed him. And my lord, in the 313 examination, he mentioned that he was drinking. So suppose if he is going to claim that his act was done out of intoxication. My lord, even that one, it can, as per section 86 of the IPC.
He is not claiming that. He's
Yes, my lord. So the act of the accused is purely murder, and his action cannot fall under the exception of section 300 IPC. And the learned trial court had rightly convicted the accused based on the direct evidence of the two witnesses, my lord.
Any
Yes, I have my
citation?
citation, my page 374.
What is the citation?
Where is the citation?
I-
What? No, which year? SEC,
okay.
what? AIR, Tintin Comics.
2023
Hmm?
SEC, 2023 11 SEC
2023 11 SEC
338.
38 para
Bahita, para 61.
61. Yes.
As regard the statement under section 313 CPC, the appellant has not given any explanation whatsoever and has not made any statement except denying the circumstances to put to her. In the fact of the present case, when the prosecution evidence categorically established the fact that the victim child was last seen alive with the appellant only, she was required to explain the circumstances leading to the demise of the child. Upon her failure to do so and failure to give the explanation with regard to the circumstances under which that may have taken place, burden of section 106 of the evidence operates heavily against the appellant.
Okay. Okay. Heard Miss
General Dinpui.
Valentina Lal Dinpui learn amicus curiae for the appellant. Also heard Miss Vande, additional PP. Hearing concluded, judgment reserved. Give me this citation also. Yes,
May I please your lordship?
yes.
My lordship, I would like to mention item number 6 of the today's daily cause list, my lordship.
Yes, yes.
With due respect, my lordship, I am praying for an adjournment in this matter, my lordship. Would like to file an affidavit to the reply of the opposition, my affidavit filed by the opposition, my lordship. So, my lord, I need 2 weeks time, my lordship. Kindly accommodate, my lord.
There is no need of reply. This is a
Yes, Your
bail
Lordship.
petition.
Lordship, Mayor, Lordship, I'm for the respondent.
Ah.
And this matter is laid before this honorable court for the sixth time. And we are not able to dispose of due to their Lordship.
We'll hear it.
This is the bail.
We'll hear it. We'll hear it.
My lordship, there is also personal difficulty of Mr. Mahajan, my lord, is the engaged counsel, my lordship, in this matter, my
He
lordship.
can appear tomorrow.
My lordship, kindly, my lordship, and also allow the affidavit, my lordship, because we have to give some vital document.
Sorry. You see, I'm more worried about your client, not about your lawyer.
My lordship, kindly, my lordship, 1 week time, my lordship, for file the affidavit, my lordship.
What is
No,
it?
1 week time, my lord.
What is
1
it?
week. My name D. Hussain, my lord. D. Hussain, my lord.
On the prayer of Mr. D. We'll fix it this week. When do you want?
Lordship, tomorrow or day after tomorrow, because I have personal difficulty on Thursday and
Okay,
Friday,
right.
Lordship.
On the prayer for adjournment made by Mr. D. Hussain, learned counsel for the petitioner, list the matter day after tomorrow. Day
Obliged.
after tomorrow.
May I seek your lordship indulgence in making a mention, part 2, item number 7.
Yes.
My lord, if this matter may come up after a week or as per the convenience of the court, my lord.
You are for whom?
I'm appearing on behalf of Joseph, respondent, my lord.
Joseph. respondent.
Joseph Rentley, my lord.
The council.
Have you submitted a wakalat nama?
Yes, my lord, my name was there, my lord. Rosie.
Item 6, part 2 or
Item number 7, my lord.
part?
Part 2.
Part 2. Okay, part 2. Say that. Okay. Yes, any objection? On the prayer for adjournment made on behalf of Mr. Joseph L. Rinsley, which is not objected to by Mr. A.R. Malhotra, this is the matter on?
After a week, my lord.
After a week.
I'm open.
Oblige.
Your Lordship, regarding item 6 of part 2, Your Lordship,
Yes.
I was recently apprised by the appellant, specifically yesterday evening, that during the course of the trial, his lawyer became the additional PP in the same court.
Yeah.
And then
This lawyer became what?
his counsel became the additional
Additional
PP.
PP.
In the same corruption court. This
Ah.
is a PC Act matter. And without informing him, his junior took up the case without informing the appellant. And the junior's counsel father was one of the prosecution witness in this case.
Okay.
And that is why, and the junior counsel advised him not to make any defense witness except himself. So, Your Lordship, if I may be given time to verify this statement.
You see, you verify, and if you say it's true, then you have to file an affidavit. We cannot just accept, because you have to give a chance to the lawyer to make a counter to your submissions. Okay. Right.
A week's time to verify.
We'll give you a week time, 2 weeks time. How much time?
2 weeks.
Okay, right. Mr. Jonathan L. Silo, counsel for the appellant, seeks time to obtain, to verify the information that is received by him with regard to the prosecution of the appellant before the learned trial court. List the matter after 2 weeks.
Please, your lordship. In respect of item number 2, my lord, in this case, there is a new implement which is respondent number 7 recently in item number 2.
Item number 2 of part 2.
Yes, my lord. So I've been approached by the said newly implemented respondent number 7. I'll be filing my power within this week.
Okay,
So
Mr.
if 2 weeks time may be granted.
Mr. Victor L. Rate, learned counsel for the respondent number 7, submits that the respondent number 7 was implemented only on when?
5/3/2025.
5/3/2025.
Yes, my lord. Thereafter, they have taken steps.
Good stuff.
I was the first-
He
last
submits
one.
that he has been recently engaged and would like to file Wakalatnama on behalf of respondent number 5.
Seven.
Respondent number 7. List the matter after
2 weeks, my lord.
2 weeks.
And item number 1, my lord.
Yes.
If this may be taken up on tomorrow, Mr. Silram Zhao, senior counsel, I have taken his consent.
Tomorrow.
Or day after, as
Day after we'll try. Day after we'll
your
try.
lordship had already had this matter on 2 occasions.
No. Maybe we'll try day after.
Wednesday.
Lordship, item number 3, this may be taken up on Thursday.
Okay.
May I please your lordship? Part 2, item number 8.
Yes.
Ms. Joseph Elderly has recused from the case then.
Huh? Who has recused?
Mr. Joseph Elderly.
He has recused from the case.
Yes, then
So what is to be done now?
may I be allowed to file my
Acha, you will be
potential-
appearing.
Yes.
Your name is?
Lalpian Fela Chongthu.
Okay, Mr. Lal Pierfera Chongtu submits that he will now be appearing for the appellant as the earlier counsel has recused from the case.
Yes, my lord.
When are you filing a Wakalatnama?
This week, my lord.
He submits, Mr. Lal Pierfera Chongtu submits that he will be submitting his Wakalatnama during the course of the week. Accordingly, list this matter after the week.
Maybe next week, my lord. If you please.
You file what? Okay, list the matter in the next week.
Oblige, my lord.
My lord, in respect to part to item number 9, with the consent of the parties,
Huh?
with the consent of the parties, part 2, item number 9, with the consent of the parties, may this matter be fixed as a list item, a fixed item on Tuesday,
Tuesday means tomorrow.
next week, Tuesday.
Okay, Miss
Jacinta Zothanmoy.
On the prayer of Miss Jacinta Zothanmoy, list the matter on next Tuesday, huh? As a fixed item. Okay.
Mr. Vice.
Then who else?
Seek Lordship's indulgence in mentioning item 11 of part.
11 years.
Yes, one of the councils have consented the matter to be heard on Wednesday. Of Lordship.
Wednesday.
Oblige.
Motion, item 1.
Yes, what is your case?
Maybe, Your Lordship, the main grievance of the petitioners is that although they have been transferred and posted as the principals of extension training centers since 2017 on provisional basis and since 2022 on, they've been
You have been
confirmed
transferred and posted as
principals of extension training centers
extension training centers where?
at Thingsut, here, Pukpui and Colosseum.
Under what?
SIRD here.
So this is a society.
Yeah. If Your Lordship will see.
If it's a society,
No, but
what is your post? What is the post? No, what is your substantive post?
co-faculty.
No, yeah, what? Let us see your order, appointment order.
Yes, yeah. My appointment order, Your Lordship, is at page 31.
Assistant Director.
/ core faculty, bracket agriculture.
Assistant Director, Core Faculty.
Petitioner number 1 is core faculty agriculture. Petitioner number 2 is core faculty economics, page 32. And petitioner number 3, Your Lordship, is community development, which is at page 37.
Now, where is your appointment as principal?
Annexure 10, page 42. This is on provisional basis.
Page 42.
20th of April 2017, page 42, Your Honor.
Page 42, 24/17. Yes.
As decided by the State Level Advisory Committee of SIRD and Panchayati Raj Mizoram at the resolution number 6 of its 43rd meeting held on 7th April 2017. Following officers under the SIRD and Panchayati Raj are transferred and posted as follows with immediate effect. Appointment of faculty to the post of principal ETC is on provisional status. We appear at serial number 3, 4, and 5. Principal of ETC Kolosi, Tingsul Tia, and Pupui. And at page 57, annexure 13, Your Honor, the transfer and posting has been made on substantive basis in 2022. Page 57, annexure 13.
Page 37, 47. what?
57, page 57, annexure 13. If I may read, Your Honor. In pursuance of the decision of the State Level Advisory Committee, governing body of SIRD and PR, in its 53rd meeting on 1st June 2022, duly approved by an administrative department, white letter number so-and-so dated 27 June 2022. The competent authority is pleased to order posting of the following faculty members as principals of extension training centers on substantive basis within the coterminous framework of ETCs on the post and post creation order mentioned against their names with immediate effect. So the main grievance is, Your Honor, we have been posted against the post of principals since 2017 on provisional basis, since 2022 on substantive basis, but we have not been paid the the pay of principal.
What is the RR for post of principal?
Your Honor, they have no RR at present.
There's no RR.
Yeah, it is being,
There is a RR. There is a RR for this core faculty.
yes.
So,
The,
what is and prior to you all being appointed to that post?
the grade pay of core faculty is 5,500.
4,000.
5,500.
5,400.
Yes. And the grade pay of the principal is 6,600.
And
Now it is level 11.
maybe whatever.
Yes.
I'm not on that.
Yes.
Now the issue is, prior to your appointment as the principal,
Yes.
did other persons hold that post of principal?
There were other principals and they were posted out and I was posted in.
So it's intertransferable or something?
Yes. So if your Lordship will see annexure 10,
Page.
page 42.
Yes.
Serial number 1, if your Lordship will see,
Yes.
Dr. M.S. Dongliani, principal of ETC Pukpui. She has been transferred as senior core faculty agriculture and serial number 5.
No, just tell me one thing. You are not a senior core
I'm
faculty.
a core faculty.
So what is your next promotional post?
Yes,
As per your RR.
As on date, there's no RR. They are
No.
drafting it.
So how does one become a senior core faculty?
Early on, yes. You have to be promoted. Yes.
So there is a promotion.
Yes, there was. As on date, there's no.
What do you
Because
mean
the,
there was?
the rules are being redrafted.
No,
Yes.
maybe read after it, but the rules are still remain the same. It has not been repealed.
Yes.
Until there is a repeal, that old rules are still applicable for core faculty members to be promoted to senior core faculty members. The rules will still be there.
According to our information, it has been repealed and they are drafting new rules. And now there are two sets of rules for those core faculties who are funded by central fund, they have a separate RR which was already drafted. And those 4 faculty who are funded by under the state fund, a separate recruitment was being drafted for them.
So all those information is here in your writ petition or not?
No,
So you have given me only what you want me to.
No, Your Worship, that is because now my grievance, Your Worship, is that since I have been given the responsibility and the duties of principal, and on substantive basis since 2022, provisional basis 2017, there's nothing in this rule that, and there's nothing in these orders which bars me from enjoying the pay scale of principal.
But how do we know the principal has to have that much pay scale?
Your Worship, if Your Lordship will see the retention order, at page 64.
Yes.
Your Worship will see this is the office order, 1st of April 2023. The
Yes.
page 64.
Yes.
The following posts have been created, white number so-and-so dated 26/3/2018, are hereby retained under Regional Campus Center SIRD at Policy for year 2023-2024. Principal, serial number 1 is level 11.
One post.
Yes, Your Worship. And page 65.
Yes.
ETC Pupui, ETC things here, level 11. So the post of principal is retained against level 11, which has not been given.
No, but what I don't understand is, if you see, you have now gone into the place of the earlier principal who has been transferred out as a senior core faculty, but you are core faculty. Now, can you be given, so now senior core faculty, what is their pay scale? Is it the same as principal or is it lower than principal? Because we, by passing a order, we might be causing problems. We have got to be careful of all the issues.
Your Worship, the main grievance, Your Worship, is, as Your
No,
Worship
yeah,
will see
main
here.
grievance, I
But,
know.
Your Worship, if Your Worship requires some clarification,
Yeah.
I can always submit an additional affidavit.
Do that, I think. You have got to submit. Yeah, you see all the issues. Now you have, I do not know whether you have spoken about central core faculty here and the state plan core faculty in the writ petition is not here, I think.
Yeah, because
So
now,
all those things you see, yeah, because unless we take into consideration all those issues,
Your Worship, that is a very grey area. If notice is issued, the state can provide all the details, because as they have created 2 separate recruitment rules. One for those posts which are centrally funded, and those posts which are state funded. The recruitment
and
rules.
are they transferring people from the central funded to the CES? Are there separate posts for the state funded core faculty members?
It will have to be separate now, since the RRs are going to
No,
be
no, I am
separate.
asking you. You're working. You should be knowing.
Yes.
I'm asking you. You have to.
I
you
don't
have
think
to,
it will be intertransferable.
I don't know. You see, that is what.
But Your Worship, the
you,
pay- the
you
pay
should
of
have.
principal-
You should ask your clients. Your only thing is that substantive principle. Okay, I should be. But we have got to look at the things
Your
in a
Worship will
larger
kindly
perspective.
what you want me to clarify, Your Worship, then.
Yes, yes, madam. I think you have to clarify also. You see, one thing is this. First of all, rightly or wrongly, you have put the petitioner as principal on a substantive basis. There are no rules. Nothing is there. Now, he has replaced, he is a core faculty member, and he has replaced the earlier principal, who is a senior core faculty member. Now, the promotional post of a core faculty member is a senior core faculty member. Now, so it's like having a joint secretary and a deputy secretary both being eligible to be promoted as secretary. In normal circumstances, that should not be allowed. How it has to go step by step. So you'll have to see how can a core faculty member become a principal when the earlier principal was a senior core faculty member. Now, another thing is that is there a dearth of senior core faculty members who can be promoted as principals? Otherwise, how is a core faculty member being made a principal if they are senior core faculty members? So we'll have to see, and we have to see the pay scale of a senior core faculty member. What is the grade pay of a senior core faculty member? Any idea?
Your Worship, I think core faculty, senior core faculty and principal are basically, I think, the same equivalent post.
Then it should be a promotion
Yes.
or an officiating appointment.
But instead of using the word promotion, they have used the word transfer and post.
Let them clarify. We'll see.
Yes.
A lot of things need clarification. You know?
And you also will see this page 57. It has been approved by the administrative department.
No, that's all right. I'm not on that.
Yeah.
You see, whatever,
The hierarchy-
if you are entitled to anything, you'll get it. The only thing is that there should not be more problems cropping up, because now there are two aspects of this matter. Now there is a thing of, like he said, centrally
Funded.
centrally funded core faculty members, and this
State funded.
now this post of principal, it comes under the state plan or the central plan. I've got no clue. So you have got to see all this. Right. Heard Mr. A.R. Malhotra, learned counsel for the petitioners, who submits that despite the petitioners having been made to hold the post of principal of extension training centers under the State Institute of Rural Development, bracket SIRD, which is a society registered under the Mizoram Societies Registration Act, 2005, the petitioners have not been given the salary of principal of extension training centers. Next para. Right. The petitioner's counsel submits that the petitioner number one was appointed as assistant director / core faculty bracket agriculture on 21/7/2011 in the scale of pay of rupees 15,600-39,100 plus GP 5,400. Don't say plus, just say GP 54 grade pay 5,400. The petitioner number 2, on the other hand, was appointed as assistant director / co-faculty bracket economics on 28/7/2011, and the petitioner number 3 was appointed as assistant director / co-faculty bracket community development
Page 37.
on 3/10/2017. 2013 under the SIRD system. Next para. The petitioners were thereafter
Page 42.
transferred and posted as principals of extension training centers bracket etc on provisional basis, on provisional status, vide office order dated 20/04/2017.
Page 57.
Yes, sir. And principles of ETC, scholarship Thing Sul Kle and Puk Pui. Full stop. Thereafter, while office order dated 5/7/2022 issued by the Director SIRD, the petitioners were posted as principals of ETC on substantive basis within the court terminus framework of the ETCS. Full stop. Next para. The petitioner's counsel submits that despite the petitioners having been posted as principal ETC on provisional basis on 20/04/2017 and on substantive basis from 5/7/22, the petitioners have not been paid the pay scale of the principal. That is, what is the pay scale of
Level
principal?
11.
That is level 11. How much is level 11?
No, level 11 is above this.
I guess it is above, but no one is going to claim a lower pay.
And Your Worship, just
That is
one-
11/11, huh? 11/11. Full stop.
Just one more information, page 67. The
67.
petitioners had submitted a representation
Ah.
for the enjoying the pay of the principals.
Ah.
At page 67, this is the minutes of the 57th meeting of the State Level Advisory Committee.
Ah.
And if Your Lordship will kindly go to page 70,
Yes.
resolution number 5.
Yes.
Request for pay upgradation for ETC principals from pay matrix.
Man,
level-
this is a recommendation.
No, this was a representation submitted by them, which was considered by the State Level Advisory Committee. Page 70.
This is 24. You are
Yes,
claiming from 22. You cannot.
No, you're just trying to bring to your Lordship information that the matter was considered by the respondents.
Maybe.
And it was if I might just read page 70, para 5.
No, you see, out here there's nothing to show that it's level 11. This is only the minute.
Yes, Your
This has to be approved.
Lordship, that is why, just the relevant portion, second last line of page 70.
Yes.
The committee advised SIRD and PR Mizoram to examine the terms of reference of the governing body and to find out if it is within the power of governing body to authorize such promotions. So the matter was considered by the State Level Advisory Committee and it advised the SIRD to examine whether the governing body had the power to authorize such promotions, which has not been done till date.
So what do you want?
I'm just bringing to your.
Do you want to issue notice or you want me to direct them to take a decision?
I'm just bringing to your Lordship.
Okay, right.
Notice.
Next, right. Issue notice returnable in 4 weeks. Ms. Lalnun Rui accepts notice on behalf of
Respondent number 1 and 2, Your Lordship.
1 and 2.
Yes, Your Lordship.
That's all. Who else is there? Who is for 3?
3 and 4 also, Your Lordship, they can accept notice because they come under the Rural Development Department.
I don't know. I'm leaving it up to her. Yes, what to do? Or we
I
should take steps or what?
Your Lordship, I will be seeking instructions if they will be taking a separate counsel. Since
Okay, we'll
they are
take 1 and
slightly-
2. A petitioner will take steps for service of notice upon the response number 3 and 4 by registered posthuity. No problem because they are a society. Okay, next para. The I'll list the matter after. No, before that, you write. The issue needs to be considered carefully in as much as as per the existing rules, it appears that the promotional post of a core faculty member is senior core faculty member. It has also been submitted Further, it had also been submitted by the petitioner's counsel that there is no service rules or recruitment rules pertaining to the post of principal etc.
As on date.
as on date. Also, the earlier principals of etc. were senior core faculty members, which is the promotional post of the petitioners. The pay scale of senior core faculty members and grade pay and the grade pay of and the scale of pay of the principal etc. would also have to be looked into. Full stop. Next para. The respondent should also take a decision as to whether don't say that. They say it had also been submitted by the petitioner's counsel that there are core faculty members under the central fund and core faculty members under the state plan. As such, the issue to be considered is whether core faculty members under the central fund can be transferred to posts under the state fund and vice versa. Full stop. Also, whether the post of principal etc. would be open to both the core faculty members of the central fund and state fund, or whether the post of principal is to be can be filled up not only by core faculty members but also by senior core faculty members. List the matter after 4 years. So I think broad idea of what's required can be gone into.
Admission, item 2.
My lord, the present petition is filed under Article 227, my lord.
227. Why?
It's a challenge against the impugned judgment and order in review petition, my lord.
Review petition.
Review petition, yes.
No, you cannot challenge. What you cannot do directly, you cannot do indirectly. You see, you can file an appeal against the judgment and order, impugned judgment and order. Give me order 47, CPC. How can you challenge? You see,
Actually, my lord,
first of all, you've got to see one thing. When you see 227 cannot be used just like that. You have to see whether did the court who passed the review order, who considered the review, was he not having the jurisdiction to try the case?
My lord, in that regard,
He has got the jurisdiction to try the
yes,
case.
yes, yes.
If he has got the jurisdiction, then where does 227 lie?
My present case is that actually it's not something like challenging the impugned judgment and order. It's like a petition seeking the authority of this honorable court to look into the manner as to how the order was passed by the trial court before passing the.
You can always file an appeal. You have to file an appeal.
My lord, thing is that when the judgment and order was passed, I do not have the knowledge about the presence of the issuance of the judgment and order. Actually, my lord, the original.
What is
suit-
the case about? Just tell me the case.
The case is about declaratory suit, my lord.
Ah,
Declaratory suit, wherein it was filed in the year 2018,
filed by whom?
filed by the respondent number one.
Ah, so he filed a declaratory suit against
Yes,
some land.
Yes, yes.
Then what happened?
After that, the judgment and order was passed.
After hearing you?
No, no.
Not hearing you.
The ex parte order was order for proceeding the case ex parte against me was passed, but that much I do not have any knowledge. And only
Then,
after
then you can always file a order 9 rule 13 petition for setting aside an ex parte order.
my lord, in that regard, the thing is that the judgment and order was passed after proceeding case ex parte, and that judgment and order attains its finality when
So-
I acquired the knowledge. My lord.
When, yeah?
When I acquired about the presence of the case, on the judgment and order was passed already. When
Maybe, it doesn't matter. You can, so you did not receive any notice,
no, not at all.
but the court must have said that you received notice.
The presumption was drawn, my lord. Presumption was drawn.
Declaratory suit, the order was passed when? Impugned
The
order.
declaratory suit judgment order was passed on 28/3/2019. And before that, the ex parte proceeding order for ex parte proceeding was passed on December 2018. And next, 2019 March, judgment and order was passed, my lord.
This is not the way to go about it. You cannot go like this. What cannot be done directly cannot be done indirectly. Your basic grievance is with the orders passed by the trial court, not by the review court. Your basic grievance is with the trial court order. You have got to challenge it by way of an appeal. That is very clear. Radhe Shyam's case is very clear. You cannot go about indirectly what you can't do indirectly.
My lord, here the reason of preferring a review petition before the
Let us see the ex parte order.
My lord, if your lordship may kindly see the impugned judgment and order. My lord, the retyped copy is at page 51. If I may go to 52, page 52, my lord. This is the copy of the judgment and order in declaratory issue number 1 of 2018.
Just a minute. You are what you are called to now.
I am, yes, defendant number 1, my lord.
But where is the order saying that notice has been served upon you? Nothing is there.
Yes, nothing is written.
You see, Madam, Mr. Counsel, you see what you can do is, you can, this 227 petition will have to go. The only thing you can do is you can file a order 9 rule 13 petition
Malo.
against that order. You can take a recourse to section 14 of the Limitation Act for
Malo.
delay,
Malo.
and also the judgments of the Supreme Court with regard to COVID.
Malo.
Okay. But how can you challenge a civil court order in a case of this nature? I can understand. You see, 227 will only lie when the court does not have the jurisdiction to try the case. Out here, it has the jurisdiction. You have filed a review. When you have filed a review to that same court, you cannot now say that court does not have jurisdiction. 227 is pertaining to jurisdiction. It's got very limited scope.
Malo.
Because you see, by your review itself, have you understood what I'm saying?
Malo. Amen.
So you see, because of your review, you have accepted the jurisdiction of that court to be proper. Now you cannot come under 227. That goes. So best thing is you file an order 9 rule 13 for setting aside the ex parte order, saying that there is no finding that there has been that no notice was served upon you. And even if there is a finding made by the court, you have got to show this finding is not based on the materials on the record. You look at it. I do not know. You'll have to see the records. And if that is not possible, then you can always file an appeal.
Malo.
A proper appeal, not by this. So either I pass an order dismissing your petition, or you want to withdraw to approach the proper forum by way of an appropriate petition. What do you want? I can pass an order.
We don't, Malo.
Because this petition, you see, sometimes I notice also that civil court orders, they challenge under 226. You cannot do that. Civil court orders will have to go under that. 227 can be challenged only when there is some jurisdictional issue involved.
My lord, in that aspect, the reason why I am approaching this honorable court before Article 227 is that I have one particular case under 227.
Give me.
But it's a completely different case, my lord.
Because even I have got one case. Not only you, even I have got one Supreme Court case. I thought I will see, compare.
This is the order, my lord.
Supreme Court.
But the facts of the case is a bit different, my lord.
Yes, so it says here, in the case of Surya Dev Rai, the apex court has held that the power of superintendence conferred on the High Court under Article 227 is administrative as well as judicial and is capable of being invoked at the instance of so. The paramount consideration is so. May be exercised sparingly in cases occasioning grave injustice or failure of justice when the court has assumed a jurisdiction which it does not have, or has failed to exercise the jurisdiction. Okay. Yes, so out here this is slightly different. Out here the petitioners were aware of the pendency of the airship case, and despite that they did not take part and instead filed a review.
Yes, this is regarding condoning the delay, my lord.
Correct.
Declining.
So it has assumed, so so the review court has exercised jurisdiction beyond,
Yes, yes, that is
because
correct, ma'am. That is correct.
that aspect, though the review court knew that the petitioners were aware of the airship certificate and did not take part, but still condoned the delay.
Correct.
That's a different thing. It's not applicable. You want, I can do it either way. What do I pass the order or what?
Maybe withdrawn, my lord.
Withdraw. Okay, right. Mr. F. Lal Yada, learned counsel for the. Let me take out this. Counsel for the petitioner says that he may be allowed to withdraw the writ petition and to enable the petitioner to file an appropriate petition before the appropriate forum against the impugned judgment and order dated
28/3/2019.
28/3/2019, passed in Declaratory suit number 1 of 2000. Mr. Zoram Chana, learned counsel for the
Respondent number 1.
respondent number 1, and Ms. Caroline Kendum Waipui,
Respondent 2 and 3.
respondent number 2 and 3 are present. The prayer of the petitions counsel is allowed. Writ petition dismissed has withdrawn, with liberty as paid for.
My lord. Obliged.
Obliged, my lord.
Item 3.
Di China kan DB matter akan CAV akan date wo CAV akan CAV akan.
My lord, we have submitted the affidavit in reply.
Huh?
We have submitted the reply affidavit.
Lordship, we have received the same this morning, so if the matter may be listed for admission hearing. I'm appearing as requested by Mr. Bilaram, standing counsel for refunds.
Okay. From 60 to 62. You have been brought into the teaching faculty, correct? You have been brought into the teaching faculty, that's what they say. Right. Where is your senior?
Lordship, he's having some personal difficulties today.
In the low court?
No, my lord.
Where?
At home. At home.
At home?
Yes.
Okay. Right. Mrs. Emily L. Chantel, and counsel for the petitioner. And Mr.
Lomo Maralte.
Lava Maralte. Pray that the matter may be listed when? After a week? After 1 year? 2 years? When?
2 weeks, my lord.
Why?
My lord, as per the convenience of the court.
Why?
My lord.
Why 2 weeks?
Any time will be fine, my lord.
Huh?
Any day will be fine.
After a week. After a week.
Obliged.
Item 4.
Yes, Lordship, in this petition, the petitioner and the respondents have come into an agreement.
Okay.
Yes, if I may be allowed to submit that meeting minute.
So we close it with this.
Yes, Lordship.
But when will you complete the process? I think you should complete the process at the earliest. Okay. Right. Heard, mister?
This is open, sir.
Your name is here.
Yes, Lordship.
TC is Hansang, learned counsel for the petitioners. Also heard, Miss
Respondent number 1. For respondent number 5.
Zaid Msangli CGC. For respondents number 1, Miss Caroline Lumoypui, learned counsel for
Respondent number 5.
5. While Mr. Samuel, you're there? Marshal Chamte, additional AG appears for 2 and 3. Next para. The petitioner's counsel submits that the matter pertains to the petitioner not having been given compensation for they've constructed a road over a land.
Yes, Lordship, it is within the ROW.
For compensation for construction of a road over the lands of the petitioners covered by LSC numbers 3091/19/01/425 of 2007 and LSC number CHP-63 of 1994. That's all. Only these two.
Yes.
Full stop. Next para. The counsels for the parties submit that an agreement has been entered between the parties in terms of the meeting minutes issued wide memo number B full stop 19022/2023-DC bracket CPI bracket close 264-265 dated Champai 11/11/2024 which has been issued by the Additional Deputy Commissioner and CALA Champai District. Next para. The contents of the meeting minutes dated 11/11/2024 are reproduced herein below as follows. Which has been made a part of the record and marked as Annexure X is reproduced herein below as follows. Today is 26.
Yes.
Okay, from here. Okay. Not for to here to sorry here. It's Amin thing, Amin. In view of the submission, in view of the settlement of the parties, the writ petition is closed as instructed. However, the parties shall ensure that the compensation to be paid to the petitioners is done at the earliest.
Item 5.
My lord, apologies, my lord. My appearance may be entered as the standing counsel for NHIDCL, my lord.
Oh, okay. Standing counsel NHIDCL.
Obliged.
Standing counsel for respondents number 2 and 3.
2 and
Additional 18 and 11.
My lord.
On behalf of respondent number 4, I have not yet received instructions. If finally be-
On behalf of respondent number 4.
Yes, my lord.
5 you mean?
My lord, I am for respondent number 1 to 3. I'm seeking
Okay.
2 weeks time for filing.
Ms. Zainab Sapu CGC for the respondents number 1, 2 and 3 and Ms. Caroline K. Lungoipui for respondent number 4 are granted 4 weeks time to file affidavit. List them out after 4 weeks.
Obliged.
Orders. Item 7.
Item 7.
Yes,
So you are appearing for whom, madam?
My lord, I'm appearing for the respondents.
For the respondent.
Yes, my lord.
So
I have
parties
yet
are
to sub-
present.
Yes, my lord. I have yet to submit my affidavit in reply.
No, this is appeal, madam. There is no affidavit.
Sorry.
Not required. Its only thing is that LCR is required, I think. LCR has not been called for. है ना? I think LCR has not been called for. What does this matter? You're right. Okay, this is come for the first time.
Yes, your lordship.
Okay, okay. What is this case?
Your lordship, this case pertains to Nathial, wherein a road was constructed, a roadway was constructed to a water pump house in the year 2011. And initially, the respondent had not claimed any objection. However, 2 years later on, they had sent a report to the DC office. And then the district court awarded them the compensation.
So you're challenging compensation on what ground?
On the ground that, your lordship, first of all, they had not initially informed the appellants about the existence of their crops and their lands in the concerned area at the time when the construction was happening. There was no objection raised in 2011, and they had only made a complaint in the year 2013 or 14, your lordship.
And the land was, road was constructed when?
In 2011 itself, your lordship. It began in January 2011 and then it ended in.
So if you can, you see that is all subject to verification. If there is no crop.
Yes, your lordship. At the time, there was verification done as well, wherein it was found that there was no objection, and also the members of the VC was also present at the time of the verification, and no objection was raised at the time, your lordship. In 2011, there was no objection raised.
No objection raised to what?
As to any ownership or any claim for damages to crops or land.
But land is there.
Assuming it is the judge.
Okay,
has,
anyway, we'll hear. Okay, heard Miss Leonard Counsel for the appellant, who submits that the impugned judgment and order dated 24/3/22 passed by the court of the senior civil judge Lunglei in civil suit number 6 of 2018 should be set aside. Issue notice returnable in 4 weeks.
Yes, your lordship.
Before that, right, admit the appeal, call for the LCR. As the respondent is already represented. All the respondents. How many respondents are there? As all the respondents are represented by Miss Emily L. Changte. Service complete against all the respondents. List the matter after 4 weeks.
Obliged, your lordship.
Hearing item 4.
Lordship.
Who's for the other side out here? Huh? No, who is appearing for the respondents?
Present today, Mr. Jonathan Larintuanga.
It has been adjourned on 2 occasions.
It can be heard by anyone. Why does it have to come before me? I've just noticed it has been coming before me only all the time.
Right.
Why? It can be heard by anyone.
Yes, no problem. But the thing is, Your Lordship, since the matter has come over.
Only thing is that
before
there's no one
Lordship.
here on the other side. I'm ready, but there's no one here. Now, what to do?
I was just thinking if the matter can be, the facts can be placed before Lordship, matter may be
No, I
continued
don't, I
tomorrow.
don't, I, see, I don't, I used to do, I have stopped doing that. Because what happens is sometimes the councils don't appear. Then we are wasting time. Not only my time, your time, everyone's time. Who is this Jonathan?
Jonathan is
El Silo?
No,
not El Sino.
Jonathan Larintuanga. Then the councils are H. Laltan Puya, E. Lalchuan Vora,
H. Lal Tanpuya, yeah, I know. What to do?
we have certain other items like item number 1, hearing fixed for
Wednesday. Ah. Then they are fixed, their case fixed for tomorrow also. And the Thursday also. We'll list it next week or the week after. We'll list it after.
All right.
Okay. All right. Mr. Siradam Zawa appears for the appellant. No one appears for the respondents. Private respondents. No? No one appears for the respondents. This is the matter after the week.
Matter for today.
They don't, huh?
Over for today. There's nothing.
But I've got some dictation to do, so it's okay.
Hello, am I audible? Hello, Aizil Benz, am I audible? কৰিলে Hello, hello, hello. Hello, 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 Azul Bench. Hello, hello, Azul Bench. কোনোবা আছে নেকি? কি কৈছে? ইয়াতে কেমেৰা নাই নেকি? ইয়াতে কেমেৰা নাই? হেল্ল'। নহয়, চবে যদি কিবা হেৰি কৰে আকৌ। হেল্ল'। কাৰোবাক ফোনত পেলাই এতিয়া। Yes, Azul Bench. Hello. Huh? Hello. Hello. Hello, Azul Bench. Hello, can you hear us? Yes, are we audible? Sorry, can you be a little loud, please? Can you please increase your volume? Just one sec, one sec. Volume board Thomas. Hello. I think the volume from your end is a little low. No, no, no. The volume is very low from your end. Full details. আমারটা ঠিকই আছে। Yes. It's a little better now. But I think it can be increased a little bit more. Okay, okay.
Fail hearing.
Fail hearing item 1.
Yes.
Sir, are we audible from here?
I can hear you. I couldn't hear the council.
May it please your lordship. May it please your lordship. May it please your lordship.
You can hear me, I think.
We can hear you, but the volume is very low.
Acha, Mriganko, you I can hear. I
know.
couldn't hear the council.
I can understand. Just 1 minute.
I put it near the mic. I put it near.
There's some issue with the sound over here.
Acha.
May it please your lordship.
Yes.
Lordship, the petitioner is behind the bar for the last 2.5 years, lordship. Basically, I am before your lordship on the ground of non-furnishing of ground of arrest, lordship. Non-furnishing of ground of arrest, lordship. Kindly peruse page 35, lordship.
35.
Probably there is a certified copy of the notice under section 50 CRPC, lordship.
Yes.
Page number 35, F for the lordship.
Page number 35.
F for the lordship.
Annexure F.
Notice under section 50 CRPC, lordship.
Yes, yes.
Lordship, there is a certified copy, lordship.
Yes.
No ground of arrest was communicated to me during the time of arrest, lordship.
Where is the arrest memo?
Arrest memo at page, lordship, 36, lordship. Interestingly, lordship,
Yes.
in the arrest memo, lordship, kindly look at bottom number, column number 8, lordship. Signature of witness, lordship.
Yes, yes.
No signature of witness was taken during the time of arrest, lordship, which is a clear violation of section 36 of the BNSS, lordship. Section 36 of the BNSS, lordship.
Section 36 of BNSS.
Kindly peruse section 36 of the BNSS, lordship.
BNSS.
Section 36, lordship.
It to BNS alone, BNSS.
BNSS.
BNSS. Kami lo pete kaka adang po kami pete. Kati lai mas sabi kami lo pete kete le kabu ko ka. Hello, where am I? A wife. Yes.
Section 36, column B, lordship.
Yes.
Prepare a memorandum of arrest which shall be 1. Attested by at least one witness who is a member of the family of the person arrested or is a respectable member of the locality where the arrest is made, lordship. No signature of the arrest, no signature of witness is there in arrest memo, which is at page number 36, lordship.
Yes, sir.
Now kindly peruse page 35, lordship, regarding notice, lordship.
Milo pevekte khale kabuka. Vai. Hey, he hello me. Yes.
And regarding notice, lordship, it is a clearly mandated that ground of arrest should be communicated to the petitioner as per section 50 of the CRPC, lordship. Moreover, in this regard, I place
Section 50 is no more applicable now.
on now 47 and 48, lordship. Kindly peruse 47 and 48, lordship. In BNSS, lordship. Section 47, lordship.
47.
BNSS, Lordship.
Yes.
A person arrested to be informed on ground of arrest and of right to bail. 47.1. Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. 2. Where a police officer arrests without warrant any person other than a person accused of a non-bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf, Lordship. In this regard, Lordship, the Honorable Supreme Court has in several judgments, Lordship, I have placed the list of judgments before your Lordship. In Prabir Purkayasto and Bihan Kumar clearly stated that if no ground of arrest is furnished to the accused person at the time of arrest, it will amount to violation of fundamental rights under Article 22(1) or 2 of the Constitution of India. Lordship, kindly produce the Constitution of India, Lordship. Constitution of India, Lordship. Article 22, Lordship.
Yes.
22(1), Lordship.
Yes.
22. Protection against arrest and detention in certain cases. 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defendable by a legal practitioner of his choice. Lordship, it is clear in the Constitution also. And on the basis of which the two judgments by the Honorable Supreme Court in Bihan Kumar and Prabir Purkayasto, Lordship. Prabir Purkayasto, Lordship. 2024 8 SCC 254.
Yes.
Kindly peruse paragraph number 19, Lordship, of Prabir Purkayasto, Lordship. Lordship.
Yes.
Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offences under the provisions of so and so, or for that matter, any other offences, has a fundamental and a statutory right to be informed about the ground of arrest in writing, and a copy of such written ground of arrest has to be furnished to the arrested person as a matter of course and without exception at the earliest. The purpose of informing to the arrested persons the ground of arrest is salutary and sacrosanct, in as much as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody, remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental right granted under Article 22(1) of the Constitution of India, Lordship. Then kindly peruse paragraph 21, Lordship.
Yes.
Of the same judgment, Lordship.
Yes.
21. The right to be informed about the ground of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused, Lordship. Now, most importantly, paragraph number 48, Lordship,
Yes.
of the same judgment, Lordship. 48.
Yes.
It may be repeated at the cost of repetition that there is sufficient difference in the phrase region of arrest and ground of arrest. The region of arrest as identical in the arrest memo are purely formal parameters, that is to prevent the accused person from committing any further offence, for proper investigation of the offence, to prevent the accused person from causing the evidence of the offence to disappear or tampering with such evidence in any matter, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigation officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas, Lordship, the ground of arrest would be required to contain all such details in hand of the investigation which necessitate the arrest of the accused. Simultaneously, the ground of arrest informed in writing must convey to the arrested person all basic facts on which he was being arrested so as to provide him an opportunity of defending himself against custodial demand and to seek bail. Thus, the ground of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest which are general in nature, Lordship. So it is specific, Lordship. Kindly peruse the judgment of Bihan Kumar, Lordship.
So what is, in short, what is
Lordship.
the difference between reasons for arrest and grounds for arrest?
So here basically a difference is clearly stated, Lordship. Here grounds of arrest should be specific, Lordship. Why a person has been arrested, Lordship. It should be specific that why he has been arrested in that regarding the involvement in that particular case, Lordship. Lordship, it kindly peruse Bihan Kumar, Lordship.
Yes.
This is 2025 judgment, Lordship. 2025 SEC online SC 269, Lordship.
Yes.
Kindly peruse paragraph 14, Lordship. Lordship.
Yes.
Thus, the requirement of informing the person arrested of the ground of arrest is not a formality, but a mandatory constitutional requirement. Article 22 is included in Part 3 of the Constitution under the heading of fundamental rights. Thus, it is the fundamental right of every person arrested and detained in custody to be informed of the ground of arrest as soon as possible. If the ground of arrest are not informed as soon as may be after the arrest, it would amount to a violation of the fundamental right of the arrestee granted under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by law. The procedure established by law also includes which is provided in Article 22(1). Therefore, when a person is arrested without a warrant and the ground of arrest are not informed to him as soon as may be after the arrest, it will amount to a violation of the fundamental right granted under Article 21 as well. In a given case, if the mandate of Article 22 is not followed while arresting a person or after arresting a person, it will violate fundamental right to liberty granted under Article 21 and the arrest will be rendered illegal. On the failure to comply with the requirement of informing ground of arrest as soon as may be after the arrest is vitiated. Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second, Lordship. Now, kindly peruse paragraph 16, Lordship, of the same judgment, Lordship. Paragraph 16, Lordship.
Yes.
An attempt was made by learned senior counsel appearing for first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody and now a charge sheet has been filed. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such arguments with great respect to the learned senior counsel will amount to completely nullifying Article 21 and Article 22(1) of the Constitution. Once it is held that arrest is unconstitutional due to violation of Article 22(1), the arrest itself is vitiated. Therefore, continued custody of such a person based on orders of remand is also vitiated. Failing a charge sheet and order of cognizance will not validate an arrest which is per se unconstitutional, being violating of Article 21 and 22(1) of the Constitution of India. We cannot tinker with the most important safeguards provided under Article 22. So, based on these two judgment, Lordship, the coordinate bench of this Honorable Guwahati High Court have passed several judgment, Lordship. Some of them I have placed before your Lordship. Basically, on these two judgments of the Honorable Supreme Court, Lordship.
Okay. Yes.
Lordship, here I have a lot of arguments to be made, my lord. Today I think it will be difficult for me. Otherwise, my lord, one thing is there. Lordship may kindly peruse Article 22.
Yes. 22. Yes.
In Article 22, if I am not wrong, my lord, in Article 22, there is nothing which says it made it mandatory that it has to be in written. The word the written is not there.
What has the Supreme Court said? Should it be
My
written?
lord, that my lord, I am coming to the point, my lord. Then, my lord, Supreme Court, prior to passing of my lord, Bihan Kumar and Prabi Purkaistha, these things initially came into a case of Pankaj Bansal. In Pankaj Bansal case, the Supreme Court has discussed this point whether and held that it has to be given in written form by grounds of arrest. Then, based on Pankaj Bansal case, this Prabi Purkaistha case, my lord, relied on Pankaj Bansal case, and Prabi Purkaistha case also said that it has to be given in written, and then my lord Bihan Kumar case has come. And the thing is that, my lord, in Pankaj Bansal, that case has been, the order has been delivered on 3/10/2022. And in my lord Ramkishore Arora versus Director of Enforcement, the Honorable Supreme Court has held that, my lord, this Ramkishore, my lord, this Pankaj Bansal judgment will be applicable prospectively. Here in the instant case, the person, because your lordship may
What is the
notice, my lord, because
citation? What is the citation you are relying upon?
my lord, that is fine, my lord. Today, my lord, Ramkishore Arora versus Director of Enforcement, my lord, this is I have taken out from live law, my lord. The exact citation is not before me.
But unless you give me that, how will I decide?
Yes, my lord, I will give it. I will give it, my lord. If necessary, I will produce, my lord, written argument if necessary for lordship permit me, my lord.
Your case is that it should apply only prospectively.
Yes, my lord, because this law has been developed from the case law of Pankaj Bansal, my lord, and that has been discussed in Prabi Purkaistha case, my lord, which my learned friend has already relied on, my lord. Because, my your lordship may appreciate the fact that in Article 22, the basic aim of Article 22 was to inform the person arrested and so that he can take legal recourse, my lord, legal help, my lord.
Correct.
That is the main, my lord, intention of Article 22.
Yes.
Subsequently, the procedural law has been developed by different judgment of the Honorable Supreme Court and different High Courts, my lord. In, my lord, 1962, my lord, that case has been referred in Prabi Purkaistha case, my lord. On a constitutional bench, my lord, in respect of Article 22(5), lordship may kindly appreciate it. That was in respect of Article 22(5), which is preventive detention, not in respect of Article 22(1). Supreme Court said that, my lord, it has to be given in writing, and that relying on that judgment, for Prabi Purkaistha case was passed, my lord. And Prabi Purkaistha case, before that, this Pankaj Bansal case was there. That has not been referred by my learned friend, my lord. From there, this issue that this grounds of arrest has to be given in writing came up, my lord. Then
The judgment which says that it shall be prospective in nature.
Yes, my lord.
Is laid down by how many judges?
Ramkishore Arora versus Director of Enforcement, my lord. I will give the Ramkishore Arora versus the
Arora.
Yes, my lord.
Versus
Directorate of Enforcement.
Directorate.
In, my lord, criminal appeal number 3865.
Just a minute. Criminal appeal number
3865.
3865
of 2023.
Of 2023.
My lord.
You should have given me all this before you should have given it to the court master, the petitioner.
Yes, my lord. Then actually, that was my mistake on my part, my lord. I took out just sometime before, my lord. And, my lord, there are other issues involved, my lord. Actually, I am little feeling difficulty here arguing that because the person has been caught red-handed. To that point also, I have some submission need to be made, my lord.
Okay, so what to do?
May I submit one thing, lordship?
Yes.
May I submit one thing, lordship?
Yes.
Lordship, with regard to the point red-handed, lordship,
yes,
that issue was already raised before this honorable court, lordship.
Yes, my lord.
That issue was already raised before this honorable court, and this honorable court in bail application 629 of 2025, lordship.
629 of
2025, lordship. 629 of 2025, lordship.
Yes.
Raised this issue and sorry, lordship, 1229. Sorry, 1229 of 2025, lordship.
Yes.
I've already where is my case law in this topic. This issue of red-handed was discussed, Lordship, in this honorable court, Lordship. And this and the coordinate bench of this honorable court has held that regarding the non-furnishing of ground, the issue of red-handed or not red-handed, the issue of red-handed or not red-handed will not come into play.
No, that is
It
correct.
is
I'm not on that.
clearly discussed.
Let me finish first.
I am not on that. I am not on that. I am not on the red-handed part. I am on the issue of the prospective part.
My lord,
Whether it
regarding
should be
prospective
decided
in
prospectively
nature,
or
in
not, huh?
our coordinate banks in my lord BA number my lord 1100/25.
Ah.
If I am not wrong, my lord, our coordinate banks has also held that it will be prospective.
110 BA
1100
BA 1100 of
25, my lord.
2025. Okay,
Yes.
decided on
Decided perhaps, my lord, on 115,
15.
my lord.
So I think let us see all this because I don't have the materials. You all have not
Yes, yes, my
produced
lord.
all
Yes,
this.
yes.
We'll fix another date.
My lord.
If you want, in the meantime, you can submit your written argument if you
Yes,
want.
my lord.
Whatever. Okay, but you please give your list of citations prior to the hearing to the court master,
My
so
lord.
that we can be prepared
My lord.
with
My lord.
your submissions. Okay. Now you see, you are making submissions with regard to some orders that have been passed, but which are not before me and which
Yes,
cannot
yes,
be
sir.
taken out just like that.
Lordship may fix any date in this week.
So you give all these citations, you give it to the court master,
My
all
lord.
the things and all your written arguments, if any, that
My lord.
also
My lord.
soft copy, okay,
My lord. My lord.
so that it can be conveyed here. So when do we fix this matter?
Lordship, any date next week, Lordship.
Huh?
Any date next week, Lordship.
Any date next week. You all choose a date. Both of you can choose a date.
5th of June, Lordship.
5th.
Lordship.
Okay, right. On the prayer of the parties, list the matter on 5th.
In the meantime, if they want to file objection, they may.
In the interim, the PP may file, additional PP may file his written objection and written argument, comma, if any. That's all. Okay.
5th of June, Lordship.
He came out, no?